Welcome. My name is Troy Harris, and this will be a brief introduction to expedited arbitration under the commercial arbitration rules of the American Arbitration Association. It may be helpful to start off with a basic understanding of what arbitration is. Arbitration's a dispute resolution process that's characterized by a binding decision rendered by a third-party neutral. Now, it's worth unpacking each of those elements a bit. Arbitration is final in the sense that it's the decision of the arbitrator and it's not subject to any further appeal. There are very limited grounds for challenging an arbitrator's award. Under the Federal Arbitration Act in the United States, for example, the grounds for challenging an arbitrator's award include such things as fraud, corruption, or misconduct by the arbitrator. Just getting the law wrong or the facts wrong generally isn't enough. It's binding in the sense that it's not simply a recommendation. Whenever parties agree to submit a dispute to arbitration, they agree that they will be bound by the award, and that award can be enforced in the same way as a court judgment. Finally, the decision by a third party, quote, neutral, means that the arbitrator has no connection to the case or the parties. And there are two aspects to neutrality: independence and impartiality. Being independent means that the arbitrator has no vested interest in the outcome of the dispute. Being impartial means that the arbitrator is not biased in favor of one party or the other. One of the features of arbitration that's generally thought of as an advantage over court litigation is that arbitration is a confidential process. Unlike court proceedings, information that's submitted in an arbitration is not a matter of public record, and the hearings themselves are not open to the public the way a court proceeding is. Second, discovery is generally more limited in arbitration than in court litigation. There will usually be some exchange of documents between the parties and maybe a few depositions in an arbitration, but that's often about it. The right to conduct discovery in court litigation, on the other hand, is generally much broader, at least in the United States, and often accounts for a substantial part of the cost of proceeding in court. Third, I mentioned arbitration is characterized by a final decision rendered by the arbitrator, which means that for all intents and purposes, there is no appealing the decision. This is, of course, unlike court litigation, where the proceeding in a trial court may well be reviewable by at least one appellate court, and sometimes more than one. Fourth, in an arbitration, parties generally have the ability to choose the arbitrator, or at least participate in choosing the arbitrator, depending on what the arbitration agreement says and what the arbitration rules are that the parties are operating under. This can be a big advantage where the parties want the decision maker to have some subject matter expertise, as for example in construction disputes. In litigation, by contrast, the parties are simply assigned a judge who may or may not have any particular expertise in the subject matter of the dispute. Finally, it's important to note a huge difference between arbitration awards and court judgments in terms of enforceability. When the dispute involves parties from more than one country, the award will be considered an international award, which is enforceable as a matter of right around the world. This is because of an international treaty known as the New York Convention. Judgments of U.S. courts, however, are not enforceable as a matter of right outside the United States. They may get enforced essentially as a favor, but not as a matter of right. With that background about arbitration in general, it's useful to contrast expedited arbitration under the AAA rules with regular arbitration. The first point to note about expedited arbitration under the AAA commercial rules is that there's a separate set of rules governing expedited arbitration. These rules are contained toward the end of the AAA's document, Commercial Arbitration Rules and Mediation Procedures, which is potentially confusing if you're looking for a separate document. I've included a link to the commercial arbitration rules, including the expedited procedures later in these slides. Expedited arbitration, as the name suggests, is designed to be fast track. The expedited procedures apply automatically if the amount in controversy is less than $75,000 and there are only two parties. And if no party's claim exceeds $25,000, there's generally no live hearing. The arbitrator decides the case on the basis of documents alone. Where there is a live hearing, it's generally not more than 1 day. In a regular arbitration, there's generally an exchange of documents followed by a hearing that can be a day or a week or several weeks, depending on how complicated the matter is. The parties can agree to proceed under the expedited procedures even if the amount in controversy is more than $75,000 or there are more than two parties. So this can be a very efficient way to resolve even high-value disputes, although the trade-off for speed and efficiency may be a greater chance of the arbitrator reaching a different conclusion than would have been the case after a full-blown arbitration proceeding. Stated differently, the expedited procedures err on the side of getting it done rather than getting it right necessarily. Nevertheless, where getting a result quickly is as important as getting a favorable result, which sometimes can be the case, the trade-off's probably worth it. In an expedited arbitration, there's a single arbitrator who's paid on a flat fee basis, usually around $1,000, whereas regular arbitration typically involves either 1 or 3 arbitrators, depending on the amount in controversy or the parties' arbitration agreement. And the arbitrators are paid at an hourly rate. In expedited arbitration, there's generally no exchange of documents beyond what the parties submit in support of their own positions. In regular arbitration, there's some limited amount of discovery, albeit not as extensive as what one would get in court proceedings. The AAA's expedited procedures have very strict deadlines for responding to the demand for arbitration, scheduling the hearing, and rendering the award. In regular arbitration, on the other hand, the deadlines specified in the rules are often extended by agreement of the parties or on order of the arbitrator. I've included here links to a couple of resources that may be of use. One is simply the AAA commercial arbitration rules, which include the expedited procedures. Second is a link to the AAA's form submission agreement. This can be useful where the parties have not already agreed to arbitrate their dispute, as for example where the contract between the parties doesn't have an arbitration clause. If the parties decide that they want to arbitrate a dispute after it's arisen and it's not already subject to an arbitration clause, then they can use the submission agreement form to get the process started. And both of these documents are easily findable just by Googling those titles. Thank you very much for your attention. I hope you found this useful. If you have any questions or would like me to send you the PowerPoint slides, just send me an email at troy.harris@harrisarbitration.com and I'll be happy to get back to you.